Okay, so we're going to get started. So firstly, I would like to start by thanking all of you for being here today and taking the time to learn more about the value of pre-planning. Because Arbor has locations coast to coast, some information may vary from province to province. The only provinces or territories we are not is excluding PEI, Newfoundland, and of course the territories like I just mentioned. My name is Sylvie Powell, and I am the Advanced Planning, Funeral, and Cemetery Director, serving various locations throughout the GTA. My focus is simply to educate individuals and provide family options for planning funeral and cemetery ahead of time. I have been a licensed funeral director since 2001. As a matter of fact, my colleague and I, Monica, who will be joining us shortly, along with my other colleague, Dan, graduated together from the funeral service education program. Again, my passion is to empower individuals with the power of choice and how they want to be remembered. I love to travel, and my goal is to visit every provincial park our beautiful province has to offer. My most recent experience is a trip to California, actually, with just a little bit of something to share at the end of August with my family. And we visited the renowned Forest Lawn Cemetery, where the late Michael Jackson, Elizabeth Taylor, and Walt Disney are all resting amongst 225,000. So that's what I like to do on my spare time. Now I'm going to introduce you to my two colleagues who will be joining us today, Monica and Dan.
Good afternoon, everyone, or if you're joining us from the West Coast, good morning to you. My name is Monica Valatalo, and it's a privilege to present today to the National Association of Federal Retirees. Welcome to you all. As Sylvie mentioned, she and I became funeral directors in 2001, so that's over 20 years ago already. And during that time, I've served families in the capacity of an at-need funeral director, taking care of arrangements and delivering funeral services following a death. Then 9 years ago, I made a change and moved into the pre-planning area to help families with advance arrangements for both funeral and cemetery. I maintain a dual license in Ontario and work within the Toronto area predominantly, although I'm licensed to offer services within the province. Prior to my career in bereavement sector, I worked in the long-term care for 15 years. My purpose in life, as you may gather from my history, is to help those most vulnerable, to be a support and provide information so I can help people make educated decisions about what's available. There's a quote by Pablo Picasso I love that reads, "The meaning of life is to find your gift. The purpose of life is to give it away." That's a principle I choose to follow each and every day. A little personal fun fact about me, I'm a former Miss Helsinki from the Toronto International Caravan. My background is that I'm Finnish and I do speak the language. If there are any Finns among us here today, huomio ja hyvää päivää teille. I'm a lover of world travel with the perspective of seeing how other people's lives, experiencing different cultures and foods from around the world. While we've been limited in the last couple of years with the pandemic, people are beginning to travel more. And so I too am looking forward to getting on the road less traveled. And so now I'd like to introduce to you Dan.
Oh, geez, Dan, you're muted right now. Do you want to unmute and start over?
That always helps. Thank you. So good afternoon, everyone. My name is Dan Riley, and I'm a licensed cemetery director and funeral pre-planner with Arbor Memorial. It's been since 2008 that I've been working out of Capital Funeral Home and Cemetery, located in the Ottawa Valley, right here in our nation's capital. Over the span of my career, I've taken great pride in the fact that I've provided thousands of families with peace of mind by assisting them with both their cemetery and funeral pre-planning. For those of you who may know me, know that I absolutely love my dogs. I have a real passion for camping and spending time in the great outdoors. But enough about me. First of all, for those of you who aren't familiar with Arbor Memorial, we're a Canadian family-owned and operated business. We were founded in 1947, and currently we operate both cemeteries and funeral homes from coast to coast. In fact, we have over 40 cemeteries and 90 funeral homes all across Canada, and we've been growing throughout the years and expanding our services. It's been since 1947 that we at Arbor have had the privilege of serving over 1 million Canadian families. And just last year alone, over 26,000 Canadian families turned to us in their time of need when they lost a loved one and chose us to provide services to celebrate the life of their loved ones. Our vision at Arbor is really that we put families first, creating end-of-life events that celebrate their loved ones in a way that is meaningful to them. So we're very experienced in the area of serving families in this way, and we'd be honored and privileged to have you consider pre-arrangements with us so we might serve your families as well.
I would like to share that this information is also available in French for you could respond with your preferences accordingly. Following today's session, I'm fully bilingual and will be available to help you if that is more comfortable for you. Okay, so we completely realize that death is not an easy thing for any of us to talk about, yet it's something that's going to affect each one of us at some point. Our hope is that by the time we complete this presentation, you'll have more knowledge than you logged on with today, and that you will feel comfortable reaching out and to continue the conversation. Monica and I will be walking you through your guide to funeral pre-planning, and Dan will be expanding on his expertise in the cemetery. And as Monica mentioned, the three of us are all duly licensed and will be able to answer any of your questions following today's session. Okay. A recent survey has showed that only 1/3 of Canadians initiated difficult end-of-life planning conversations. I understand that this can be a sensitive topic, but after many years, my experience working for Arbor and helping countless families along my journey, I try to impress that planning matters. And in fact, matters that most celebrations that we plan to continue throughout life. Funerals are no different, and in fact, it can be challenging to plan under the pressure of very little time, sometimes limited resources, and under duress. Of the third of Canadians who started planning conversations last year, our experts share that 57% said the conversation went as they expected, 24% felt it was a tough conversation, and 19% found it was less difficult than imagined. And so our licensed professionals are able to lead the conversations with you or your family in the comfort of your home, virtually or in person, whatever makes you comfortable. I want you to think about the person that will be finalizing your funeral arrangements for a moment. Now, I want you to think about what life may look like for that individual, because that person, whether it be a friend or a family member, is the reason that you want to further this conversation and help make the experience kinder. Most of us purchase insurance to prepare for the worst, those events that we hope will never happen. Avoiding the topic does not make the simple truth go away. Our experts tell us that there are 87 decisions, which we will touch throughout our presentation, and choices that need to be made following the death of a family member. There are important details that will need your attention, and someone will have the responsibility of completing these tasks all in just under, most of the time, 72 hours. Insurance is only the financial component. There are other components that need to be thought of. we consider pre-planning a piece to your security puzzle. And those pieces include other planning points, like you can see today, in life, such as estate planning, retirement plan, investments, health insurance, just to name a few. It's quite evident and simple. Knowing what's involved in advance provides you the opportunity to make decisions on your own behalf. So why not address this task personally now and simply itemize the details to save undue hardship for loved ones tomorrow? We know that planning allows us to truly think about our options and choices. We will now pause and watch a short video for just a moment.
Let's talk about something that no one wants to talk about or even think about. Something that no one's been able to avoid regardless of economic or social status. Life, like any good story, has a beginning, middle, and an end. So let's talk about death. Life's final chapter. For now, let's acknowledge that death visits every one of us sooner or later. Planning our final arrangements ahead of time can help relieve pressure on family and friends. To start, you need the facts to navigate through the process. You need to know what questions to ask yourself and how to determine what matters most to you and those you love. Then, you can record your wishes and discuss them with your family so that there's no doubt in anyone's mind. One of the most important questions to ask yourself is, how does your final chapter read? How do you want to be remembered? If you prefer the traditional approach, then you can have a religious funeral service and burial. If you prefer something more modern and contemporary, then your ceremony and final resting spot can reflect your passions. Maybe you're a bird watcher and you want bird songs playing at your service. Maybe you're a rider and you want a procession of motorcycles. Maybe you're a scuba diver or an avid chef. The point is, your final arrangements will be exactly as you want and will reflect your taste, culture, lifestyle, and budget. And you'll have made your passing considerably less stressful for your family and friends. You want to choose a funeral home and cemetery that can accommodate every wish, no matter how unusual, one that can provide a complete suite of services and take care of everything for you. Once everything else is in place, you can decide what financing structure best suits your lifestyle and budget, allowing enough time to discuss payment schedules with your family. With pre-planning, you can cross one big thing off your to-do list and get on with the story of your life.
At Arbor, we have a solution to pre-planning. The thought of pre-planning one's funeral may seem overwhelming, and let's face it, funerals are not exactly something we discuss over Sunday night family dinners. While there may be hesitancy to talk about funerals, we're here to help normalize that dialogue around preparing for that difficult time. Because when you plan for tomorrow today, we believe that your confidence and convenience should begin from the moment of your call. The planning process comprises 4 steps, and we're going to talk about those today. The first is to consider your needs. What thought, if any, have you given to funeral pre-planning? How do you want to be remembered? What's your legacy? We wear many hats in our lifetime, as adult children to aging parents, perhaps as parents ourselves, as spouses, siblings, professional titles, community members of organizations that come together with a shared purpose, like the NAFR. Those roles define our value systems in great part, and those values help us to navigate life's important decisions. We take the time to learn about you, to consider and discuss your wishes, and create a plan that's as unique as you are. Step 2. When pre-planning, there's much to consider, and information will be required to ensure things like your vital statistics are recorded to complete registration through City Hall or through the Registrar General, and other necessary documents to ensure final details are followed through. We offer a free family registry to help in gathering those details ahead of time. This tool allows you to record the whereabouts of important documents, such as your will and powers of attorney, insurance papers, passport, and other legal identifications. The family registry is a workbook that allows you to indicate personal wishes, like charitable organizations you may want memorial donations made to that reflect your personal interests, or perhaps favorite song or musical selections you'd want featured in your funeral playlist. Eulogy notes and other biographical details to help coordinate a meaningful and personal service. Some of the most beautiful tributes I've seen have nothing to do with how much is spent, but on the time we take to be reflective and craft a service that speaks to one's passions and interests, such as a vase of forget-me-nots from Mom's Garden, a Star Trek themed memorial card, or everyone wearing your favorite color on the funeral service day, or a memorial toast by a close friend during a reception. Compiling your information in a single essential resource for your executor and family members will help make their jobs easier at the time of need. Step 3 is to create your unique plan. Once we've had time to discuss and consider your needs and you've gathered your important documents, we can help facilitate that conversation and incorporate traditional and/or contemporary options available that reflect your taste, culture, and budget. People often ask, how much does a funeral cost? Is cremation cheaper than burial? The reality is, we're all driven by our financial ability to make decisions in keeping with what we can afford. And for anyone who's been in the position of having to make arrangements when someone has passed away unexpectedly, it's the worst position to be in, to make decisions that can cost thousands, even tens of thousands of dollars payable upfront. Most of us don't have that kind of money, and certainly I don't. Pre-planning now is the best gift we give our families by removing the uncertainty from decision-making, in documenting your wishes in advance, and securing today's costs versus tomorrow's inflation. Step 4, completing the final details. So in this final stage of arrangements, we identify the value of your plan with an itemized contract that clearly details those decisions you make. Whether traditional one-day visitation, same-day option, memorial, celebration, those details are recorded, and we outline the various time payment plans available, from 1 to 20 years in some cases. Know that premiums are commensurate with one's age, and costs are protected by insurance, meaning that if you were to pass away within the midst of their time payment plan, any balance owing is covered by the applicable insurance. No matter what plan you may choose, there are a variety of options to suit every budget, with ample time to discuss best payment schedules in keeping with your comfort level. Once plans are finalized for funeral or cemetery, we ensure the plans we make now continue to meet your needs. We recognize that sometimes plans change with time. So too, there's flexibility where needed to modify decisions should you wish. Arbor has the added privilege or benefit of the travel plan called Journey Home that enables portability with your plan. With over 90 funeral home locations across Canada, we honor your pre-arrangements at any of our branches without penalty at their full value. One of the many advantages of pre-planning your funeral with Arbor. So let's review the advantages of pre-planning. Number 1, that your family knows your wishes. 2, that reduces the legal and financial burden for your loved ones. By controlling how you want to be remembered, prearranging your service, and choosing a plan in keeping with your financial ability to pay, whether across 1, 10, or even 20 years, that makes pre-planning affordable. Prevent emotional overspending. Those who love us want the very best for us always, even when that can be unaffordable. Pre-planning now allows you to take control of those costs. Eliminate inflation, because when you pre-plan, that guarantees current costs, even if those contracts, services are not needed for many, many years to come. Making a difficult experience easier for those you love. Those families whose loved ones have pre-planned often report being thankful everything was in place. Decisions made now mean that your family is spared that burden later. And a family registry can help that process today.
Hi there. So I'm here to talk about the cemetery side of things today. I'd like to start by sharing a really quick video. It's only about 2.5, 3 minutes long. And the video is going to take you on a little tour around the cemetery property at Capital Funeral Home and Cemetery. It's important to note that although this video is only showing features at Capital, it really represents all of our cemeteries since we keep our locations quite uniform. My hope is that this short video will show you how unique our cemeteries are in comparison to the traditional older style of cemetery. So let's take a look at this video. So, as I had mentioned earlier, Arbor Memorial was established back in 1947 with its first cemetery in London, Ontario. Now, it's been since 1953 that families have come to know Capital Funeral Home and Cemetery as a beautiful landmark cemetery, unique to Ottawa and the surrounding area. You will see in this slide that much of the cemetery is reserved for traditional burial, with bronze memorials placed flush to the ground, so that those who pass by, our gardens look more like a beautifully landscaped park than a cemetery. But in fact, in the midst of the Ottawa Valley, Capital Funeral Home and Cemetery has over 75 acres dotted with mature trees, memorial benches, colorful flower gardens, with a tranquil pond and fountain. Capital has many different features, like an on-site crematorium and an indoor mausoleum, with glass and marble columbarium niches that are comfortable for year-round visitation. Cremated remains may also be memorialized in our outdoor niche structures or in other sections of the cemetery set aside for in-ground burial. Our full-service cemeteries also have upright memorial sections and recognize people of various faiths and cultures with special monument gardens and walkways throughout the properties. Special care is taken by the property staff to keep the grounds in park-like condition that creates a warm and friendly setting for personal meditation and reflection suitable for a peaceful and relaxing visit any time of year. Our on-site funeral home offers visitation rooms, chapel, and reception facilities, all on the cemetery grounds for the added convenience of having all final arrangements taken care of in one location. As with all of our cemeteries, we work closely with the communities in which we are situated and support various groups and charitable organizations. At Capital, for example, we have an alliance program with the Legion where we have erected a Veterans Wall of Remembrance where we hold a Remembrance Day ceremony each year. We also work with the local Firefighters Association and have a dedicated wall holding the names of our fallen firefighters. So now you can see how unique our cemetery properties are in comparison to the older style of cemetery. Now let's take a moment and have a look at these other cemeteries. Our company believes that if our prices are comparable to what people are spending right now in the older style of cemetery, then most people would probably prefer to use our gardens. Let me show you what people are spending in other cemeteries. Now, I'm sure you're familiar with this older style of cemetery, and I mean no disrespect when I refer to them that way, as I have family in a place like this. However, many people feel that these cemeteries have a graveyard atmosphere. They're difficult and expensive to maintain, and no room has been left for beautification. This may cause many people to feel obligated to overspend on extravagant personal monuments. As you can see in this photo, the national average cost for two people is just under $23,000. And of course, the wealthy person may erect a crypt with marble floors and stained glass windows. Believe it or not, those can be $100,000 or more. So why do people spend that type of money in a cemetery? Well, families may spend that type of money in a cemetery so others see their names and remember them. However, the truth of the matter is that as these cemeteries get filled, they attract very few visitors and their names are soon forgotten. You see, people visit our gardens time and time again, and I really just think it's because of their natural beauty. Our main customer is the average family, and the amount of money that the average family spends will give them much more value in our gardens. As time goes on and fewer spaces become available, our property is going to double and triple in value. And that's why our family security plan is so attractive to families today. Now, I just want to show you this chart here. This is something that has been put together, and it really just goes to show how cemetery costs don't decline. Now, looking at the chart back in the 1970s, this is based on two people, and it's based on traditional casket burial. But back in the 70s, for two people, we were looking at around $3,500 for our cemetery arrangements. I'm sure you all recall in the 80s, there was a lot of inflation. Well, cemetery costs went up quite a bit at that time as well. Now, if we fast forward to 2015, that's when these charts were last updated, We were sitting at a national average at that time, just under $23,000 for two people. What really took me back is when they did update those charts back in 2015, they've done a projection. And as you can see here, they're stating that by 2040, for two people to have a traditional casket burial, we're going to be sitting at just under $78,000. I mean, that's incredible. And it's unfortunate because it's making it more and more difficult for a lot of families to get a plan in place. Now, our company has pioneered perpetual care in Canada. And as a result, we've set up a trust fund with the TD Trust Company under a government-mandated irrevocable agreement. So it's under this agreement that we must deposit no less than 40% of our sales into trust. And it's the interest off the principal which is going to maintain our property forever. This is quite a bit different than the older style of cemetery where they really relied on people coming into the cemetery for income. Once those cemeteries are full, there is no more income. And you would often see bills being sent out to the families for the upkeep of that property. This is something that you will never see happen with us. We take a lot of pride on how our properties look. So let's say 100 years from now, when the cemetery is completely full, we'll still have this trust fund in place forever to maintain our properties and keep them as beautiful as they are today. But more importantly than that, it means that your survivors and the future generations, they'll never be faced with a bill for the upkeep of that property. So this money is used for things like maintaining lawns and shrubs, planting of the flowers, maintaining the buildings, niches, and snow removal. All to keep this place beautiful forever without any additional upkeep costs being passed on to your family. Now, here's a fact that really we all know from working with many families. There are really only two ways of taking care of these arrangements. There's sort of a plan A and a plan B, a right way and a wrong way, if you will. I guess you'd say we really don't know about plan C. These arrangements are either going to be done by us or they'll be done for us. The plan B or the wrong way, unfortunately, on the left, it involves many families who simply just don't want to have the discussion, or maybe they're uncomfortable about it. They just never get around to facing the details of their planning in this area, and that's just human nature, I guess. But oftentimes, that results in a difficult decision becoming a much more difficult one. This is a situation we see play out daily in our industry. Our company has been in business for over 70 years, and we cannot come up with a single advantage to this scenario. Usually we have a widow or one of the children sitting with us on one of the most difficult days of their life, not only having the weight of their emotions, but having to make very difficult decisions on unfamiliar terms. With this scenario, there's only disadvantages. Higher prices are guaranteed as cemetery properties increase 7 to 10% per annum, doubling every 10 years. And this scenario often leads to emotional overspending. At-need situations are always more costly than pre-need, usually by about 25%. And I really just think it's because you see families at that time thinking with their heart, not their mind, making decisions that maybe they wouldn't make if they were thinking clearly. Also, many people don't realize in order for a cemetery to open ground, we require payment in full. And because insurance settlements and wills and probate usually take weeks or months to settle, families are often left scrambling for funds, sometimes borrowing money from family or friends or taking a loan that they can't afford. As you can imagine, there's a huge emotional strain to making these decisions alone. At this point, the person faced with these decisions would likely give up just about anything to have a few more moments with their loved one to help them make this decision. And because once the decisions are made, well, they're irreversible. Now, I think we can all agree that this is definitely the wrong. On the other hand, we have plan A, the right way of doing things. When you make decisions ahead of time, you get price protection, which means you'll avoid all future price increases and will never have to pay a penny more than what you're paying today. Also, because we deal with many people on pensions or disability, we have convenient terms to really suit any budget. So if you're motivated to start your arrangements, we can work with you and make it affordable. Most importantly, though, These decisions are being made in the privacy of your own homes without stress or grief as a factor because you're making them together. You'll never have to worry about what the other would have wanted, and each of your wishes are going to be honored. We prefer to talk about Plan A the right way. Now, Plan A is a pre-planning environment where you're together, you're calm, and there are no emergencies facing you. You can take time to discuss with someone like myself all the different arrangements that are available, the options that you have, and we'll provide our family security planning kit to you, our family registry planning guide, which I'll discuss in a moment at no additional cost. So I guess one of the questions that I'd have for all of you today is, which side of the ledger would you like to be on with this planning process? We hope that you'll be on Plan A, the right side of this picture, where we can help you and make these arrangements in the most advantageous circumstances possible and the most beneficial for you and your family.
As Monica mentioned earlier, all of you today are eligible to receive our complimentary family estate planning kit and other literature to help educate you. Our family registry offers everything in one place and everything in its place. Because we meet with families at the most difficult times in their lives, we find that a lack of records causes unnecessary confusion. The family registry offers a simple yet comprehensive method of gathering all the necessary information and will help your family, lawyer, executor, or executrix. It's also your assurance that all of your wishes will be understood by everyone concerned and can be completely respected. How would you rank your life's most stressful events? To name a few are on the screen. We plan for our retirement, education funds, vacations, special anniversary. We plan because it gives us control. Planning one's funeral and cemetery arrangements is a satisfying, valuable act that gives us a sense of control over our lives today. Purchasing final arrangements in advance is an important part of a comprehensive plan for your family's security and well-being. Your experience, the satisfaction of knowing that urgent decisions have been taken care of and your family members have a clear idea of your wishes. Why choose Arbor? So we are a private Canadian family-owned funeral and cemetery company. We celebrated our 75th anniversary this year. Arrangements are transferable, meaning if life takes you to another part of the country or another city, we will help transfer your arrangements to a convenient location of your choice. As I mentioned earlier, we are in every province excluding PEI, Newfoundland, and the territories. The cost varies from $0 to depending on the cemetery location, and there is no charge to transfer your funeral arrangements. Worldwide travel protection offers unparalleled protection wherever you are. If a death should occur while out of the country or just out of town on a brief trip, bringing a loved one home can be complicated and an expensive process. Family benefits such as child and grandchild protection for in the unfortunate circumstance, should a child or grandchild pass away before you do, we will provide them with matching services to yours at one of our many funeral or cemetery. There are more details to be explained on this benefit that we could explain to you separately. Costs are guaranteed, as Dan mentioned earlier. A number of licensed professionals to assist you 24 hours a day at any one of our locations. And lastly, special discounts for Alliance members such as you, varying to varying degrees and percentage. It varies from province to province. Today, I leave you with one final thought. Someday, everyone will have to face the problem of making final arrangements. It's easier, kinder, and more economical to do it today, together. Each one of us today can influence positive decisions within our families and our communities. I thank you for your valuable time, and we look forward to continuing this conversation online at your convenience. Now, I invite Zach to speak and to share his knowledge. Zach, welcome.
Hi, how you doing?
Great, thank you.
Great, thank you. I'm going to get my screen up here. I'm going to share my screen, and I hope it works well. Okay. All right, so my screen should be up there now. Please someone chime in if you can't see it. But as you can see, I'll be talking today about the essentials of wills and powers of attorney. So before I get into that, I'm going to tell you a bit about myself. So my name is Zach. I'm a senior associate lawyer at the law firm of Kelly Santini here in Ottawa. And the firm has two convenient locations here in the city, one right downtown at 160 Elgin, and then my location, which is in the west end of Ottawa, in the PN, at 2301 Carlin Avenue. So we are a full service law firm. We offer a variety of legal services, but my services that I specialize in and that I focus on are estate planning and estate administration. I do some real estate as well and some family law agreements, but really I'm building my career towards estate planning and estate administration. So just to give you an idea of what I'm going to talk to you about today, we're going to focus on powers of attorney and wills. We're going to start with powers of attorney, which are usually needed before because they apply when someone's alive. And then we'll work our way to wills. And when we talk about wills, we're going to talk about them generally to start, and then we're going to work on the specifics of the different things, the different decisions you're making within your will. So let's start. So powers of attorney, they're separate documents from each other. There's a power of attorney for personal care and a power of attorney for property. And these documents are your ability to name someone or some people to make decisions for you when you are incapacitated or incapable of making those decisions yourself. So the power of attorney for personal care deals with decisions like treatment, long-term care, short-term care, nutrition, and it only applies when you are incapacitated, when you mentally cannot make those decisions for yourself. Now, power of attorney for property, on the other hand, deals with financial matters. Management could be managing finances. It could be, if your house needs to be sold, things like that. Now, it applies not only when you're incapacitated, but can also apply when you're incapable. And there's a fine distinction there to note, but when you're incapable, you could have capacity, but not be capable. So physically incapable to manage your finances. Say you are too ill to get out of bed, but still mentally with it. Or say you are traveling and you're stranded in another country and you can't come back to Ontario, can't come back to Canada to deal with your affairs. So both documents are very important to have in place. Most people come and contact me because they want a will, and then I advise them that obviously as part of their full estate planning package, they're going to want to make sure they have powers of attorney as well. Now, people who do not have powers of attorney are running the risk of losing capacity or capability and having their loved ones have to make what's called a guardianship application to court to become appointed by the court to be a guardian of personal care or a guardian of property. Now, these applications are very expensive. They are time consuming, especially, these days with the pandemic probably causing quite a bit of backlog in the courts. And it's uncertain. The judge makes a decision on who can or cannot be your guardian based on the evidence that your lawyer would present. Now, you can avoid all that by getting your proper estate plan in place. And when you're choosing your power of attorney, you're choosing your POA, you want to make sure that they're trustworthy, reliable, capable, and competent. So trustworthy in the sense that they're going to always have your best interests in mind and always act with your best interests in mind. Reliable in the sense that when the time comes for them to act, that they will be there and they will act. They won't, fail to act when it's needed. Capable in the sense of physically capable. Are they around? Are they able to get to where they need to be to act for you? Are they in another country? Are they too far away? That would make it incapable for them to act. And competent in the sense that they know how to make the right decisions, even if they don't personally know what the right decisions are or what their responsibilities are. They know enough to ask professionals for help if they need it. So these professionals could be financial planners, could be accountants, could be lawyers. Competent in the sense that they know what they need to do to get the job done. But not everyone knows how to be a perfect power of attorney. So there's supports there to help. So that's powers of attorney, and I'm going to now switch gears and talk about wills. Now, powers of attorney, they apply when you're alive, but incapacitated or incapable. The moment you pass away, the powers of attorney cannot do anything. And that's when your will takes over. Your will is a dormant document that is only activated on your passing. But once you pass, it becomes the governing document that tells the world what you want, who you want to be responsible and in control of your estate, and who you want to benefit from the value of your estate. Working as a lawyer, the regular reasons why someone comes to see me for a will are usually marriage, common law relationship, maybe they bought a house, maybe they're having their first child, maybe they're having another child. But the point that I would like to make is that every adult really should have a will. I know for some people it's financially restrictive to have a will. Some people feel that they don't own enough yet, like young people, students, whatnot. I understand that, but the point is, none of us really know when our time will be, and those who pass away without wills, their estates are undoubtedly more complicated to administer because you lack the certainty and clarity that a will provides. I've been practicing law for almost 10 years now, and I've worked on many estates, some with wills, some without wills. And I can tell you right now, the ones without wills are more costly on legal fees, costly on other expenses. There's a lot less certainty there. It's something you want to avoid if you can, because with less certainty comes a greater risk of conflict. It comes a greater risk of other voices in your life trying to guess what you wanted, and then unfortunately maybe those voices conflicting with each other. With a will, you tell all your loved ones what you want. Now, another point I would like to make, another important point, is that an outdated will can be just as problematic as not having one. So wills don't expire per se, but sometimes someone will make a will 10, 20 years ago, maybe more, and the people that they named as their estate trustees are no longer capable or alive to act. Or maybe the people they named as their beneficiaries are no longer who they want to actually benefit from the value of their estate. So it's important to keep your will updated. Wills or estate planning is not a static, it's not a set and forget type of thing. It's something that is fluid, that moves through your life. Sometimes your life changes happen more rapidly, relatively speaking, and you should be updating your will more rapidly at that time. Sometimes you're at a stage of your life where you can set it and more or less forget it, but you should really honestly be checking in on your will pretty regularly, just to make sure that everything is still up to date and what you want. Other special considerations that I will mention, I don't have time today to get into the details, but I will mention them just for a bit of information to share, is people that own valuable businesses or valuable private shares in corporations, they should be considering getting a primary will and a secondary will. A primary will being dealing with their personal assets, and a secondary will dealing with the value of the corporate shares. The main motivation behind having the multiple will strategy is to ensure that the value of their shares in the corporation are not subject to a state administration tax, or as you might hear it referred to as probate tax. It's a tax efficiency that you can build in by basically having an additional document in your estate planning repertoire. Other considerations that are really important to think about is whether or not trust is needed within your will. Common trusts I see a lot of are trusts for minor beneficiaries or young beneficiaries, and trusts for those with disabilities. Now, generally speaking, my advice is always only use a trust when it's absolutely necessary. If there's no need to overly complicate your will, then try to keep things more straightforward and simple to help your loved ones when the time comes. But those two, minor beneficiaries or young beneficiaries and people with disabilities, are the most common I see. And if you felt like your circumstances needed or warranted a trust for another reason, then we get into that and we talk about that and explore that. So now we're going to focus on the specifics of wills. Generally, the first thing, or maybe the second thing you'd see referred to in a will, is who you're naming as your executors or trustees. I use these terms interchangeably. A trustee is an executor, executor is a trustee. Maybe the best term to use would be estate trustee. So these are the people that are responsible and in control of your estate. So it is a big responsibility, and it's not a prestigious role. So it's a lot of work, it can be very time consuming, but most people, with the assistance of professionals around them, like accountants, lawyers, and financial planners, and obviously those professionals at funeral homes, can get through the responsibilities and the roles and the work and the time. When you're naming your trustees, you want to name an alternate trustee to your primary, to your first choice, because it's good to have a contingency in place just in case that person you name predeceases you, or when the time comes that you pass away, they are incapable of acting for health reasons or for whatever other reason. Like I said, it is a lot of work and a big responsibility. So maybe they have too much going on in their life to say, yes, I can do this. So you want to make sure you name an alternate. Now, also, when you're naming your trustees, you can consider naming multiple trustees, maybe one or two people to work together in the same role. So whether it be the first primary role or a secondary role. Now, there's risk involved in that. And this is what I tell all my clients, is that you only ever name two people or multiple people, regardless of the number, if you know for sure that those people work well together as a team. And I mean, work really well together. Like, you wouldn't want to name two people that disagree a lot, or you certainly wouldn't want to name two people that are currently in conflict or don't talk to each other or are at odds with each other, because if you did that, you'd be sowing the seed of conflict right into your estate. That's what we try to avoid. As an estate planner, I try to avoid conflicts in an estate, because those estates I'm asking my estate litigation team to handle, and those files are very, very sad and very expensive, and it just no one really wins on those estates. So if you're going to name multiple trustees, please name people that work well as a team together, that get along really well. Because if you do that, and they do get along really well, then it can be a blessing, because they can share the burden, they can delegate duties, they can work on it together, and the responsibility doesn't just fall on one set of shoulders. So when you're choosing your trustees, regardless of what I just said, whether you're choosing one or two people, alternate or not, similarly to POAs, you want to make sure that they're trustworthy, reliable, capable, and competent. You want to make sure that they're going to always have your beneficiaries' best interests in mind. You want to make sure that they will be ready and willing to act when the time comes, and that they're physically able to accept their responsibility, like they're not, in some other country and unable to come back to Ontario or Canada, wherever you live. And competent. And again, I don't mean competent in the sense that they know exactly what they need to do as an estate trustee. It's very rare that, unless you are a professional working in the industry, that you know exactly what you need to do. Or maybe you've been through it once before and you kind of learned through experience. But either way, a really important point I want to make is that if you're named as a trustee in a loved one's will, or when you're choosing to name an estate trustee, they should know, and you should know, that people are expected to ask for help from professionals. Again, I keep mentioning these professionals over and over again, but accountants, financial planners, lawyers, professionals at the funeral home, people who work on these things on the day-to-day and as the regular practice, they will know, they'll provide you the guidance. They might not be able to do the work for you, but they will be able to give you the guidance on what you should be doing. Now, with estate planning, with wills, as opposed to POAs, you're going to want to make sure you consider the special features of your estate when you're picking your trustees. So if you know for sure that your will have a trust in it, and that trust would be, once it's active, will have to be maintained for a matter of years, you're going to want to make sure your trustees are young enough to see it to the end, or healthy enough to see it to the end, because managing a trust within an estate can be a multi-year endeavor. Now, probably the most important decision you're making when it comes to loved ones and whatnot in your will are who you're going to be leaving your estate to, your beneficiaries. So you want to make sure that you're defining your beneficiaries very clearly, that there's no ambiguity there, and you also want to ensure that your beneficiaries are updated, that they still reflect what your wishes are. Now, here in Canada and Ontario, we have testamentary freedom. We can leave our estate to whoever we want. There's some other countries out there that basically state that part of your estate, only a percentage of it you can choose to leave to whoever you want. But here we can leave our estates to whoever we want. And in that, some people choose to disinherit a family member or treat family members different from others that are kind of ranking in the same next of kin level. And that's completely fine if that's your wish. But my advice on those circumstances are always that you should take the opportunity to explain your reasons as to why you're doing that. Ideally, you'd be explaining your reasons to the people or persons that are involved or that are affected by that decision. I understand that that's easier said than done, and it can be an awkward conversation to have, and I understand that. So if you can't have that difficult conversation with your family members or the interested parties, then you should make sure that your lawyer or the professional you're helping you put together your will knows the reason why you're expressing this wish, so that they can note it in their notes as to why the disinheriting is happening in the will. Sometimes I advise my clients to write a handwritten letter or a personal letter to keep with a copy of their will, explaining to why they've said their wishes. And sometimes I even draft in, on behalf of the testator, the reasons right in the will, so that they will be read and seen with the beneficiary provision. So the reason I say this, and the reason I take the time to mention it today, is because through my experience, I find that these situations inevitably can lead to conflict and arguments and fights between usually loved ones of the deceased. So you want to avoid that as much as possible, and you want to be the voice. You want to be the voice that people hear, or that your voice is the one that determines why and explains why you've made a certain choice. So take that opportunity. Now, as one situation that's important, and I don't have a lot of time today to get into the different considerations, but the situation where you have previous children, or you have a new spouse and you have children from a previous marriage, the dynamics there and how the estate planning laws work with the family laws, it's important to consider. It's important to take the time to discuss. So if you are hiring a professional like a lawyer to help you with your estate planning, it's always good to ask questions and about what obligations do I have to my new spouse under the family laws, and if these are my wishes as stated in the will, is there other consequences, legally speaking, that might flow from those wishes in my will. So it's very important, if you find yourself in that situation, to talk about it with your professional. Now, I'm nearing the end of my talk today, and I'm just going to leave you with some final words of wisdom. And that is to be open and upfront with your loved ones about the contents of your will. There's no need, like wills are confidential documents for sure. They're personal documents, but you don't need to keep them a secret from those who they affect and those who have named in your will or haven't named in your will for that matter. So especially your estate trustee, if you're going to name someone as an estate trustee, they should know that you've named them as an estate trustee, so that if you can see how they react to that, they might say, "Oh, no, thanks. I would never do that," and then then you shouldn't. You should probably think of someone else's name. But your beneficiaries, and especially if what your wishes are a little different than the quote unquote norm or what might be expected by the interested parties and the loved ones in your life, you want to make sure that you have an opportunity to explain, because the wills are not a great way to explain again why you're making the choices. Lately, I've been hearing about family meetings, like sitting everyone down in the same room or at the same time, or maybe on the same video call, and talking to them all at the same time about your wishes and what you want in your estate planning. That's an extremely smart thing to do. Everyone hears it from you at the same time, so there's no, they said, he said, she said. There's none of that. It's a really smart thing to do. So anyways, there's no need to keep your will secret from your loved ones, those who are interested in it and affected by it. So that's a big piece of advice I'd like to share with everyone, is to be open and upfront with that. Now, I want to thank you for your time today. Thank you for attending the meeting and letting me talk and share some information with you. My contact information is up on the screen there, and I think it will be shared a little bit later in the presentation. And I know that we're going to be answering questions, I believe. So I'm all done. I'm gonna stop sharing my screen and hand the control back over to fine people at Arbor. Thank you very much.
Thank you, Zach. So yes, we do have some questions that have come up in the chat. So one of the questions I'm going to begin with is the topic of the journey home. The journey home can be purchased separately than any funeral or cemetery arrangements, and the cost for that is $595. The other question that came up ahead of time are details available to see the contents of the policy ahead of time? And the answer is yes. Therefore, if you reach out to us after the session today, we'll be able to provide you all the necessary details to make an informed decision. I'm not sure if there's any other questions that came up in the chat box.
I see a couple directed at what I talked about. Maybe I'll address them. Is that okay?
Absolutely.
All right. So Glenda has asked, if you live in Canada, can your trustee executor reside in the U.S.? Now, the answer is yes. You can name someone who resides in the U.S. as an executor, but in doing so, you might be attracting additional income taxes onto your estate. So, income taxes of the United States of America as opposed to just Canadian income taxes. So it's generally unadvisable to do that. But sometimes people have no other options, and it is what it is type of thing. So good. That's a good question, Glenda. Now I have a question from an anonymous attendee. Zach, what do you think of appointing a corporate executive? Yeah, so there's a lot of institutions out there. I think most of the 5 major banks, have estates and trusts services where they will, usually there's a threshold. Usually there's a threshold amount of the value of your estate where they will agree to act to be your executor, and they'll do the estate administration for you. Well, not for you, but for your loved ones, for your beneficiaries. Now, what do I think about it? I think in some situations it's great. It's an excellent choice. It's a great option to have. They have a bit higher fees. They'll get you to sign off on a fee agreement. but sometimes when there's just no one else to choose in your life, when there's no options for people, that I do like the corporate executor option, because it definitely does give you that peace of mind that things will be handled and almost, I'm assuming, undoubtedly handled the right way, because these banks, these trust companies, they do it as a matter of course. This is what they do. So I guess that's what I think about it. And I'm just scrolling through to see if there's any other questions that I can answer from my presentation.
I'm not sure, Zachary, if you're able to answer regarding, there's a question here, how long can you expect to pay income tax after my passing? I'm not certain if you could answer that.
Well, yeah, it's kind of hard to answer because I'm not an accountant, but you know, you don't pay income taxes unless there's income made, right? So if you're, there's a terminal return that everyone would have to file, and then often there's what's called a trust return and I think you have to file at least one trust return, even if there is no income earned. But basically, if your estate earns income, then you have to file a trust return for those years, and it could really depend on how many years the estate, which is a form of a trust, basically exists after your passing.
Okay, I'll go ahead and answer one comment from a guest. Lorraine, thank you for your comment. That's very kind. And we have locations in every single province, excluding Newfoundland, PEI, and the territories. If you reach out afterwards, and I believe we'll be placing our contact information, I'm able to connect you with someone that will be closer to home.
There has been a few questions from several different attendees regarding the planning tools that were being offered. So we will be reaching out in the coming days. They're all complimentary planning tools. I think if every one of you in attendance could get a copy, I think that'd be great. And we certainly have them to offer. So we'll be reaching out, and anyone who does want to receive those, we'll make sure that you get a copy of them.
I also just want to add to Dan's comment that those the family registries are also available in French at no charge, and we're available to meet virtually or also in person. Zachary, there's one very good question here. How much is the cost to make a will?
Yeah, it will vary depending. I think the majority of the time, people just need a general, straightforward will. And there's different packages I offer depending on if it's two people, like spouses, making wills. But for one person, my fee for will and powers of attorney, so the 3 documents, for one person, my current fee is $895. $895. There's obviously HST on top of that and a small photocopying charge. But like I said, I have a discounted rate for spouses. It's usually spouses require what's called mirrored wills, and but the rates can go up if again your will requires trusts involved, or if you're like I mentioned during my presentation, someone who owns valuable private shares, and now we're working on a primary and secondary will, then the costs generally estimate to kind of double on those, because it's 2 times the work. Again, if anyone wants more specifics on my costs, I'm happy to talk about them with what they got going on with their circumstances and give them a quote. So there's a couple other questions here. Bill has one. Why do banks give such a hard time if you want to use a power of attorney? Probably because of liability reasons, to tell you the truth. They don't want to, they want to make sure that the power of attorney is valid and active. So it doesn't surprise me that maybe, Bill, you've had some personal experience with banks giving you a hard time with trying to use a power of attorney. It doesn't surprise me. I see it a lot. I see banks wanting to make sure, right, that the power of attorney is not only a valid power of attorney, but it's actually effective and active. Another question here, how do you know your estate's important matters are being handled correctly by the executor? Well, you can check in with the executor. You can ask. They should be providing you regular updates. And there are laws around being a trustee and executor. And if they break those laws, then there's legal consequences. So hopefully the legal consequences are enough to make sure that people act accordingly and are administering the estate in a proper way. But executors are under a duty to deal with all the beneficiaries fairly and even-handedly, and to kind of treat them. That's who you're answering to in a lot of ways, and so you can just ask. You can ask for an update if you want from the estate trustee, and they should really correspond with you and keep the lines of communication open.
Zachary, there's a really good question from someone who's anonymous. Who looks after all your digital legacy accounts? For example, the internet.
Well, that's a great question. And in all my wills that I've been drafting, unless my clients don't see a point of it, I've been putting in a digital assets clause that's relatively recently, but I'd say definitely for the last few years. At least a digital asset clause deals with a number of different circumstances and gives your trustee, your executor, your estate trustee, the ability to deal with or look after your digital legacy accounts. So hopefully that answers your question, but it would be the same person who would be administrating your estate. It's important that this day and age that digital asset clause is in your will, especially if you have important, as you say, digital legacy accounts.
Okay, and we're gonna answer our last question. And this one again is for you, Zachary. Oh, my screen. Are banks required to release the funds for the purpose of funeral expenses?
Are they required to? I don't know if they're required to, but I often see a bank, like it's rare that a bank will not release funds to pay for a funeral or burial expenses or that kind of thing, as long as they have an invoice showing the amount owing, and also obviously making sure they can relate that invoice back to their past client. I wouldn't, yeah, I would be very surprised if a bank wouldn't pay those amounts. Now, that's another reason why you should really, or I guess the person should have a will, is times that I've seen a bank maybe refuse to pay or not pay is when someone passed away without a will, and they don't know who, the banks don't know who they should be taking instructions from, because there's no will saying this is my estate trustee and this is who you should be listening to. But with a will, if you're the estate trustee, invoice in hand for the funeral expenses, I would be shocked if a bank doesn't cover those expenses. They'll probably make the payment directly to the funeral home and cover the cost.
Well, this concludes our session today. Zachary, a huge thank you for sharing your experience and staying on the call to answer all of these wonderful questions. Thank you to those who participated and who've joined us today. One final thought, we have some contact information that you see on the screen right now. The three of us are available along with Zachary to answer any further questions after this session or to just further the conversation. Thank you. Bye for now.